2부 행사 시작하도록 하겠습니다. 2022년 고려대학교 해상법 전문가 강좌 2부에서는 고려대학교 해상법의 밤이라는 제목을 좀 붙였습니다. 우리가 3년 동안 해상법 관련자들이 모이지를 못했기 때문에 좀 타이틀을 붙여가지고 약간의 좀 격식을 갖추도록 했습니다. 제일 메인은 제4회 최희식 교수 해상법 렉처를 듣는 것이긴 합니다. 그렇지만 그 앞서 3년 동안 해상법 연구센터에서 어떤 활동을 하였는지 우리 또 식구들한테 또 알리기도 하고 또 외부에 알리는 목적으로 이렇게 했습니다. 그래서 순서는 공부 나간 대로 우리 연구 교수를 지낸 이형균 박사가 3년 동안 해상법 연구센터에서 행했던 그런 업적에 대한 소개를 하고요. 그 다음에 우리 그 센터가 갖고 있는 여러 이제 부속 그 이제 연구 단체가 있습니다. 선박건조공인법 연구회가 있고 또 수산 해양수산 레저 법정책 연구회도 있고 한데 오늘은 특히 선박건조공인법 연구회 책이 이제 어제 또 발간이 됐기 때문에 그와 관련해서 우리 그 이동해 소장께서 또 설명을 해주시겠습니다. 그리고 오늘 바다 공부 모임에서도 여러분 오셨는데 바다 공부 모임에 대한 또 소개도 하도록 하겠습니다. 그리고 그 다음에 지금 망에 들어와 계신데 중국 상해해사대학의 호중랑 교수가 이제 제4회 렉처를 하도록 그렇게 하겠습니다. 그래서 마치고 나면 7시경에 우리 이해랑 또 박사님이 오셔서 축하 공연을 한 15분 정도 하시고 준비된 식사를 하는 순으로 하도록 하겠습니다. 그러면 오늘 사회는 제가 제일 분야 제일 잘하니까 하도록 하는데 그러면 우리 이형균 박사를 좀 모셔가지고 우리 해상법 연구센터가 3년 동안 있었던 그런 업적에 대해서 좀 이야기를 하도록 하겠습니다. 우리 이형균 박사는 고려대학에서 박사학위를 받고 현재 법학연구원의 선임연구원으로 가 있습니다. 고대에서 2년 동안 그 연구 교수 생활을 한 바가 있습니다. 우리 이형균 박사님 부탁드리겠습니다.
네.
인사를 좀 크게 해주시기 바랍니다.
네, 안녕하세요. 방금 소개받은 이형균이라고 합니다.
거기를 켜게 쓰겠습니다.
제가 준비한 PPT 먼저 띄우고 시작하도록 하겠습니다. 네, 안녕하십니까. 저는 해상법 연구센터에서 연구교수를 지냈던 전 연구교수 이형균 박사입니다. 네, 2020년부터 2021년까지 해상법 연구센터의 성과에 대해서 보고드리도록 하겠습니다. 네, 장표의 순서는 먼저 해상법 연구센터에서 발행하는 뉴스레터와 주간 브리핑, 그리고 각종 행사, 그리고 해상법 연구센터에서 행했던 연구 성과에 대해서 순서로 말씀드리도록 하겠습니다. 먼저 해상법 뉴스레터 업데이트입니다. 해상법 연구센터의 뉴스 업데이트는 개간으로 이제 각 분기별로 한 번씩 발행하고 있는데 2013년 1월 13일에 제 1호가 발간되었고요. 제가 있을 때였던 2020년 1월부터 ISS를 발행받아서 정식 간행지로 인정이 됐고요. 그리고 2020년 4월에 이제 제가 있을 때 리뉴얼을 해서 이제 예쁘게 발행하고 있습니다. 그래서 2020년에 이제 총 4회, 21년에 4호, 그 다음 2020년에도 지금 12월까지 총 4회가 발간돼서 이제 1년에 한 번도 거르지 않고 매년 이제 4회씩 발행하고 있습니다. 우리나라 해상법의 판례와 각종 연구센터, 해상법 연구센터의 연구 성과 등을 이제 싣고 있고요. 그리고 해상법에 관련 각종 이슈에 대해서도 법률 분석을 싣고 있습니다. 그리고 올해 최근에 추가된 것인데요. 2020년 5월 7일부터 해상법 주간 브리핑을 발행하고 있습니다. 2022년 5월 7일에 제 1호가 발행됐고 해상법 뉴스 업데이트가 이제 3개월에 한 번씩 발행되다 보니까 좀 빠른 소식들을 놓치는 경우가 있어서 이제 매주마다 중요 쟁점에 대해서 짧게 소개를 하고 있고 이제 교수님 유튜브에도 함께 올라가고 있습니다. 그래서 현재 2020년 5월 7일에 제 1호가 발행됐고 27호까지 발행된 바 있습니다. 다음은 행사 보고입니다. 먼저 이제 해운조선 물류수단 저자 전문가의 대화 바다 공부 모임인데요. 코로나19로 인해서 집에서 이제 집콕 생활이 늘어나면서 유익하게 그 시간을 활용하자라는 취지에서 시작된 모임인데 2020년 9월 19일 이제 제1회를 시작으로 현재 110강까지 강의가 완료되었습니다. 단톡방에 이제 700명 이상 참여할 정도로 굉장히 성황을 이루고 있습니다. 그리고 해운조선 물류수단 최고위 과정인데 정식 명칭은 이제 고려대학교 법학전문대학원 ESEL 아카데미인데요. 현재 총 4기에 걸쳐서 2019년부터 2022년까지 네, 2022년까지 총 4기에 걸쳐서 진행했는데요. 국회의원, 유기준 국회의원, 김성찬 국회의원, 그리고 이수진 국회의원, 최윤희 전 합참의장 등 굉장히 유력한 인사들도 많이 참여하셨고 굉장히 많은 분들이 참여하셔서 인적 네트워크와 학문적 소양을 갈고 닦아 있어서 호평을 받고 있습니다. 다음은 선박건조금융법 연구회입니다. 선박건조금융법 연구회는 2020년부터 2022년까지 총 12회에 걸쳐서 행사가 진행되었습니다. 그래서 이 행사에 대해서는 이따 이동해 부소장님께서 더 자세히 소개해 주실 것으로 기대됩니다. 그리고 이제 선박건조금융법의 이제 하부 모임인데요. 이제 사실은 이제 별도의 명칭을 가지고 이제 본격적인 위상을 가지게 된 모임이기도 합니다. 그래서 코로나19 이후 해운 물류 산업 안정화 방안을 위한 자담회입니다. 2020년 5월 24일에 제1회를 시작으로 이제 코로나 이후에 물류 대란 등 각종 이슈들에 대해서 법적 쟁점을 진단하고 우리나라 이제 해운 조선 물류 수산 분야에서 이제 안정성을 기할 수 있는 대응 방안을 모색하고 있습니다. 2020년 5월 24일부터 총 8회가 개최되었습니다. 다음은 수산해양레저 법정책 연구회입니다. 우리나라에서 수산 그리고 해양레저에 관련된 법을 연구하는 모임이 없기 때문에 이제 그런 차관에서 2019년 7월 23일에 창설되었고요. 고려대학교 학제간 연구사업에 이제 1년 반 동안 지원을 받고 있는 사업입니다. 그래서 총 2020년에 2회, 2021년에 5회, 2022년에 5회가 개최되었습니다. 그리고 바다 저널 읽기 모임입니다. 바다와 관련해서 이제 신문 기사들, 언론에 나오는 뉴스들이 굉장히 많은데 그 뉴스들을 이제 분석해서 법적 쟁점을 도출하기 위해서는 어떤 현안이 있는지를 파악하는 게 먼저기 때문에 2021년 3월 6일부터 제1회 모임을 시작으로 격주 토요일 아침에 9시부터 10시까지 모임을 진행하고 있습니다. 이 모임은 한국선주상호보험의 강동아 부장이 이제 책임져서 굉장히 잘 이끌어 나가고 계시고요. 해운신문, 해양항구, 코리아시핑 가제트, 일본 해사신문 등 각종 쟁점들에 대해서 분석을 하고 있습니다. 2021년 3월 6일 제1회 모임을 시작으로 2022년 12월 17일 41회까지 총 41회가 개최되었습니다. 그리고 오늘 개최하고 있는 해상법 전문가 강좌인데요. 매해 이제 12월 말에 해상법에 관련된 전문가들이 모여서 하고 있는 오늘 행사인데요. 한 해도 빠짐없이 총 3회가 개최되었고 그리고 해상법 전문가 강좌와 병행으로 항만물류법 세미나도 한 해도 빠짐없이 3회가 개최되었습니다. 그리고 마지막으로 이제 오늘 가장 중요한 행사인 프로페서 차이스 렉처 최희식 교수님 기념 강좌가 이제 1회부터 4회까지 총 개최되었고요. 이따가 더 자세히 설명드리겠지만 1회 강연자로 최희식 명예교수님이 하셨고 그 다음에 2회 강연자로 윤동철 해양대학교 명예교수님 그리고 3회 강연자로 김현장, 정명섭 변호사님, 그리고 제 4회 강연자로 오늘 제임스구 교수님께서 하실 예정입니다. 다음은 해상법연구센터의 연구성과입니다. 해상법연구센터가 연구 영역도 굉장히 많이 수행했는데 조선협회에서 도서사 민사책임, 그리고 선박보건성과 종강도에 관한 선박안전법 신고 의무, 그 다음에 선박검사제도, 항만시설 사용료, 해운시장 질서 확립을 위한 연구, 그리고 해상 판례와 해상법 논문 정리, 그리고 전기선 영업, 그다음에 K 소형화주 장기 운송 계약, 그리고 예선업, 그리고 해상 판례, 영덕군의 해상수산 교통건설 발전을 위한 연구까지 총 11회 연구 영역을 시행했습니다. 다음은 단행본입니다. 굉장히 많은 단행본이 2020년부터 2022년까지 나왔는데요. 먼저 김인영 교수님과 권호장 삼성화재 부장님께서 공저한 해상보험법이 이제 1판과 2판이 각각 2020년 9월, 2021년 8월에 출간되었습니다. 이 책의 장점은 선박보험, 적하보험, 건조보험, 선주창호보험 등 해상보험에 관해서 이론과 그리고 실무에서 사용된 약관에 대한 해설을 다루고 있다는 점입니다. 그리고 김인영 교수님의 교과서인 해상법 6판이 2020년 12월에 출간되었습니다. 특히 이제 일본의 해상법과 종합물류업 관한 것들을 담고 있어서 굉장히 도움이 많이 될 것으로 기대되고 있고 실제로도 많은 도움이 되고 있는 것 같습니다. 그리고 이제 오늘 더 자세히 소개하실 것 같은데 김윤 교수님이 편집 대표를 맡으신 선박건조금융법 연구가 2판이 드디어 출간되었습니다. 2022년 12월 출간되었고요. 이 부분에 대해서는 이따 이동엽 부소장님께서 더 자세히 설명해 주실 것으로 기대됩니다. 다음은 해운산업 깊이 1, 2, 3입니다. 이제 1편 이제 2020년 7월, 2편이 2021년 3월, 3편이 2021년 6월에 각각 이제 발간되었습니다. 1편은 이제 일본과 싱가포르에서 김윤 교수님께서 연구년을 하시면서 공부했던 내용들을 담고 있고요. 2편과 3편은 이제 1999년부터 2020년까지 김윤 교수님께서 신문에 이제 제시한 칼럼들을 담고 있어서 해운 전 분야에 대한 식견을 볼 수 있는 책들입니다. 그리고 다음으로는 김윤 교수님께서 이제 가장 사랑하시는 바다 공부 모임에 이제 공부했던 성과물들을 엮은 바다 저자와의 대화 1, 2입니다. 각각 이제 1편이 2021년 7월, 2편이 2022년 7월에 각각 발간되었습니다. 그래서 해운조선, 선박금융해상법, 해양사 등 바다 관련 모든 분야를 담고 있는 종합 개론서로서의 역할을 하고 있습니다. 다음은 이제 저희 해상법 연구센터의 자랑이자 가장 사람이 재산이다라는 이제 인적 성과인데요. 사실 그 2018년 이전부터 2014년 최용철 박사, 지금 현재 연변대학교 교수로 가 있는 최용철 박사로 시작으로 2018년 이전에도 저를 포함해서 굉장히 많은 박사들이 있었는데 2019년에 3명, 2020년에 3명, 2021년에 3명, 2022년에 2명, 총 최근 3년 동안 총 8명의 박사가 배출되었습니다. 그리고 다음은 석사학위자인데요. 석사학위자도 마찬가지로 이제 기존에 많은 석사들이 배출됐지만 2020년부터 2022년 기간 동안 총 7명의 석사가 배출되었습니다. 그리고 여기에 장표에 넣지는 못했는데 이제 제가 나간 이후로 이제 이동엽 부소장님께서 영입되셨고, 그리고 김원각 연구교수가 새로 영입되었고, 그 다음에 최선우 조교와 이제 서혜영 조교를 바탕으로 이제 김윤 교수님 지도하에서 굉장히 해상법 연구센터에서 열심히 활동하고 있으니까 더 많은 성원과 응원을 부탁드리면서 제 발표를 마치겠습니다. 대단히 감사합니다.
진짜 뭐 활동 많이 했습니다. 여러분 활동 많이 한 것 같은 박수 한번 다시 부탁드리겠습니다. 제가 이제 최근에 한 게 그 주간 브리핑이라고 있는데 이영규 박사가 27호까지 이야기했는데 제가 오늘 아침까지 32호까지 발간했습니다. 우리 이성철 우리 부장판생한테는 매주 보내드리는데 매주 보내드립니다. 그래서 32호까지 발간됐고 우리 해상법 연구센터 홈페이지 가면 다 올라가 있습니다. 자, 그러면 우리 이동해 부사장님이 나오셔가지고 선박건조금융법 연구에 대한 말씀을 좀 하시겠습니다. 그리고 요 책은 우리 법조계를 대표해 오신 이성철 부장님께 우리 기정하는 그런 또 식을 갖겠습니다. 잠깐만 좀 기다려 주십시오. 예. 일단 설명 좀 해주시고요.
네, 안녕하십니까. 이동입니다. 제 생각에는 이 책에 대해서 우리 김윤 교수님이 그 흥행을 좀 하면서 제가 좀 특별히 좀 소개를 하는 이 역할을 맡지 않나 싶습니다. 책 표지가 실제로 이렇고요. 실제 이 책의 시작은 1권입니다. 1권이 16년 9월에 발간이 돼서 총 여기 9분이 했는데 이 내용이 선박건조가 있고요. 조선 쪽에 있고 그다음에 선박금융 이렇게 해서 총 10개장이 이렇게 기정이 되어 있습니다. 이게 16년이다 보니까 이때 선박건조금융법 연구의 1회부터 18회까지의 내용을 담고 있어요. 근데 2016년 이후에 지금까지 뭐 벌써 한 6년이 지났습니다. 그래서 그 이후에 총 지금 48회인데 이 책에는 45회까지, 그러니까 19회부터 45회까지의 발표 내용을 축약해서 또 선별해서 총 12분의 집필진의 내용을 담고 있습니다. 이번에 내용의 좀 특징은 지난번에는 조선하고 선박금융이었지만 이번에는 우리가 계속 좀 이야기가 많이 되고 있는 센터에서 많이 이야기가 되고 있는 선주업에 대한 내용을 특별 특집으로 해서 그간의 선주업에 대한 그리스 또 우리 중국이나 일본 다양한 국가의 내용들을 소개하는 그런 특집을 마련하고 있습니다. 그래서 지난 그 7월 달에 이 목록에 대해서 정리를 하고요. 총 15분에게 의뢰를 했는데 한 2달 만에 이 발표문이 다 수집이 돼서 10월, 11월 1판, 2판이 교정판이 나와서 저희가 12월 지난 26일 날 500건을 받았습니다. 그래서 이 내용을 했는데 저는 그간에 사실은 뭐 아시겠지만 저는 금융 쪽에서 왔습니다. 산업은행에서 저는 그 해양 본부장으로서 주로 국제금융을 하다가 국제금융 안에 스트럭처드 파이낸스가 주된 내용이 선박금융이 있어요. 항공기 선박인데 저는 또 부산에서 센터장까지 하면서 주로 선박을 했습니다. 근데 선박금융을 하면 대부분의 내용이 법적인 내용이 많습니다. 계약의 내용이 많고 또 선박을 하다 보면 여러 가지 그 계약 내용이나 그 법적인 내용을 알지 못하면 금융 자체가 안 되기 때문에 그래서 그 오랜 세월 동안 법조계 분들과 상당히 친하게 하다 보니까 이 센터에 또 우리 김은영 교수님 눈에 들어서 부수장으로 제가 재능 기부를 하게 됐습니다. 저희가 조인하게 된 건 지난 9월인데요. 짧은 시기에 제가 여러 가지 제가 업데이트된 내용도 없고 아는 것도 적지만 이제 오늘 아까 우리 소개한 이 센터의 내용을 보면 어마어마한 내용이 있습니다. 저는 작은 이 책자지만 요 내용을 한번 소개를 드리고 단지 제가 좀 소회가 있다면 이 내용이 지난 한 몇 년 동안에 중요한 어떤 그 이슈들을 담고 있습니다. 동아탱크 사태도 있었고 한진해운 HMM의 내용도 있고 또 선조업의 내용이라든지 또 체인지 오더라는 이런 부분 다양한 내용들을 가지고 있는데 앞으로도 우리가 이 관련해서 이 조선 선박금융 또 여러 해양 관련 주요 이슈들이 우리 센터를 중심으로 한 연구에서 연구가 되고 발표가 되면 다음번에 또 4권, 3권, 4권으로 계속 이어질 것이라고 생각이 들고요. 그러기 위해서는 이 해상법 연구센터가 지속적으로 지원이 되고 또 지속적으로 성원을 받아서 계속 좀 활발히 연구되도록 많은 지원과 또 성원을 부탁드리겠습니다. 이상 제 소개를 마치겠습니다.
예. 이동에 우리 그 본부장님, 부소장으로 이제 재능 기부하고 계신 데는 좀 박수 좀 부탁드리겠습니다. 우리 센터에 큰 도움이 되고 있는데 우리 센터 형편이 나아지면은 잘 모시겠습니다. 그렇지만 당분간
열심히 재능 기부하겠습니다.
예, 이건 편집을 우리 이동의 본부장이 다 이렇게 하시거든요. 자, 그래서 사실 우리 최식 교수님 오늘 직접 오시면 드리려고 그랬는데 우리 법조를 대표해서 이성철 우리 그 부장 판사님한테 그 기정하도록 하겠습니다. 직접 부장님께서 사진 좀 찍어주시고 네. 조금 저 위에 올라가셔서 좀 올라가셔서 네, 우리 선박대전국민법 그리고 해상국연구센터를 대표해서 대신해서 드리겠습니다. 네, 네 감사합니다. 네, 감사합니다. 시간이 조금 지연이 됐는데 다음은 우리 박영주 교수 조금 나오시고요. 그 바다 저자 전문가와의 대화에 대한 말씀 좀 드리겠습니다. 약청에서 이제 바다 공부 모임인데요. 이게 벌써 만들어진 지가 2000년 9월부터 만들어져 가지고 많은 분들 지금 망이 한 750명 정도가 격주마다 토요일 공부를 하고 있습니다. 그래서 책자도 2권 나왔는데 고려대학교 평생교육원에 3월 1일부터 정식 강좌로 등록이 됐습니다. 그래서 한 7, 8명 전문가들이 뭐 해운, 조선, 물류, 선박금융 각 분야에 대한 강의를 그렇게 하게 됩니다. 우리 고려대학교 해상법 연구센터가 뭐 바다 저자와의 모임도 또 후원도 하고 선박건조금융법 연구 모임도 또 후원을 하고 있습니다. 이렇게 이해해 주시고 많이 지원해 주시면 참 좋을 것 같습니다. 해운 저널 읽기 모임도 제자들이 자발적으로 2주에 한 번씩 이렇게 하고 있는데 우리 고려대학교 해상법 연구센터가 우리 해운, 조선, 물류 분야에 이제 공부하는 그런 분위기를 많이 상승시키는 역할을 하고 있는 것 같습니다. 다음은 이제 메인 파트인데 최희식 교수님 렉처에 대한 설명을 최희식 교수님 애제자인 박영준 교수께서 설명을 하시겠습니다. 저도 애제자인데 저는 1호 애제자고 2호 애제자가 박영준 교수님이십니다. 또 우리 사실 최고 애제자는 이광복 변호사님인데 이 변호사님 좀 뒤에 계신데 여러분 박수 좀 부탁드리겠습니다. 이 변호사님 감사합니다. 네. 최 교수님께서 제일 아끼는 제자가 3명 있는데 제일 아끼는 제자 중에 첫 제자가 우리 이광국 변호사님, 그 다음에 박영준 교수님, 그 다음에 저입니다. 좀 설명 좀 해주시면.
안녕하십니까. 방금 전 소개받은 양호대학교 법대 박영준입니다. 이거 원래 예상이 없던 거고 김인영 교수님께서 소개해야 되는데 너무 혼자 하시는 것 같아서 아마 제가 쉬고 있는 걸 못 보시겠던 것 같습니다. 예, 다들 아시는 대로 최희식 교수님께서는 한국해상법 연구뿐 아니라 전 세계적으로 IMO 법률위원장도 지내시고 또 IFC 펀드의 또 법률위원장도 지내시고 하셔서 해상법의 전 세계적인 대가시라고 하실 수 있습니다. 그래서 저희 고려대학교 법과대학과 법학전문대학원에 오랫동안 근무하시다가 정년퇴직하셨지만 해상법 연구의 뜻을 기려서 이제 외국에서도 보통 이제 대가의 뜻을 기려서 기념하는 기념 강연을 한다. 근데 착안을 해서 이제 제자들이 한번 해보자고 했고 또 마침 또 수제자인 김인영 교수님께서 모교에 계속 남아서 또 선생님께서 하셨던 해상법 강의를 하시기 때문에 그런 면을 좀 반영을 해서 보시는 대로 렉처 오브 프로페서 차이스 마리타임 로라고 해서 가지게 됐습니다. 그래서 저희 선생님 양력은 다들 아시니까 그냥 넘어가도 될 것 같고요. 다들 아시는 대로 고려대학교 법과대학에서 교수를 하셨고 또 사법시험에 이제 차석 합격하셨고 또 사실 만 19살에 붙었으니까 굉장히 일찍 붙으셨죠. 그리고 또 영국에 가셔서 또 동양인으로서 2번째 이제 영국 베리스터가 되셨고요. 첫 번째는 아무래도 본인이 직접 돌아가신 게 아니니까 직접 하시는 게 낫겠다 해서 첫 번째는 선생님께 직접 하셨고 2019년 12월에 했습니다. 그리고 2번째는 임동철 교수님께서 2010년 12월에 했습니다. 20년인데 지금 거꾸로 가고 있습니다. 그 다음에 3회는 이제 21년에 정명석 변호사님께서 하셨고요. 그리고 이번 4회는 그동안 원래 사실은 저희가 계획할 때는 1회는 선생님께서 직접 하시고 2번째는 이제 한국하고 외국하고 이렇게 번갈아 가면서 하다고 했는데 3회 때 아무래도 코로나 상황이라서 그렇다면 학계에서 한 분 또 저기서 한 분 이렇게 한번 하도록 그렇게 했습니다. 그래서 네 번째는 이제 비록 줌이지만 저희가 상하이 대학교의 제임스 후 교수님을 이제 모시기로 했습니다. 지금 아마 들어와 계신 것 같은데 제임스 후 교수님 소개는 김인영 교수님께 부탁드리겠습니다.
예, 박 교수님 감사합니다. 제가 이제 외국에 다니면서 보니까 힐리 교수 해상법 강좌가 미국에 있습니다. 힐리 교수라고 뉴욕 대학의 강의를 하면서 변호사 생활을 했는데 이게 세계적으로 굉장히 유명한 그 렉처가 됐어요. 그래서 우리 동양에서도 최희식 교수님 정도면은 렉처를 만들 수 있겠다 이렇게 했거든요. 그래서 일본이나 중국이 그러면 안 돼요. 일본이나 중국이 못하는 렉처를 우리가 먼저 만들어가지고 저는 이게 이제 꼭 우리만 하는 게 아니라 일본에서도 오고 중국에서도 오고 듣고 하는 그런 렉처를 좀 만들고자 했는데 그동안 이제 그 코로나 때문에 외국 분들 못 모셨습니다. 이번에도 제임스 훈 교수를 한국에 모시려고 그러는데 나오시지 못한다 해가지고 온라인으로 듣도록 그렇게 됐습니다. Professor James Hu.
Yes. Can you hear me, Professor Kim?
Oh yes. I'm very sorry. We are behind the schedule. Thank you so much for attending the program. I understand that you met Professor Chai several times during our East Asian American Law Forum several times, right?
Yes.
Yes. Many the Korean professors and the lawyers told me that you are the best practitioner to be nominated as fourth the lecturer for Professor Chai's Maritime Law lecture. Thank you very much for accepting my invitation. Okay, let's start your lecture on the Zoom. Are you ready for giving us your lecture?
Okay. So thank you very much, Professor Kim, for your inviting me to share some information on the anticipated revision of the Chinese Maritime Code and to present the topic of improving the hybrid regime of carriage of goods by sea in the anticipated revision of the Chinese Maritime Code. Well, good evening, everybody. And I'm very sorry to say, well, I have not visited Korea University for 3 years. And now the situation in China is not very good currently because so many people have suffered or are suffering the disease, although the symptom is not very serious. Well, Professor Chai is very much distinguished. So I'm also looking forward to meet him once again as soon as whether in Korea or in China or any other place. Now, I will discuss briefly the 4 questions. The first question is what the hybrid regime is. The second question is why the hybrid regime has been adopted in the Chinese Maritime Code. The third question is why the hybrid regime now needs to be improved. And the fourth question is how will the hybrid regime be improved? Before we touch the specific questions, I would like to look into the anticipation of the revision of the Chinese Maritime Code. Well, the Chinese Maritime Code was adopted 30 years ago. Is there any problem with my PPT? Professor Kim, please wait a moment.
Please put your mouse now.
Yeah. 小齐有什么问题吗？
No movement.
我翻了没有显示的吧？我已经在翻了，那我再重新共享一遍吧，好吧？ Yeah, there's a problem, right? I will try again. Well, Professor Kim, can you watch my PPT?
Oh, the first slide is still on the screen. So
But not to the second page or the following page.
we need to see the second slide, but
So you can only watch my first slide.
yes.
And now on my computer, it's the second slide.
I see. 그럼 어떻게 하면 돼? 우리가 받아서 하면 되나? Professor James Hu, please send me your PPT
Yes.
email, and then we will handle your PPT in Korea University's computer.
Okay. Well, now I already was sent to my PPT to. No. So I will just send to my PPT to your email. Okay.
Yes, yes, please.
Yeah. Sorry. Please just wait to 1 minute.
제가 그 제임스 후 교수에 대해서 좀 설명 좀 드리겠습니다. 제임스, please. 제임스 후, Professor Hu.
Yeah.
I would like give a short introduction about you to the audience in Korean. Okay.
Well, it's a waste of time. So I already sent to my PPT to your email address.
Okay. 제임스 교수는 대를 해설해야 졸업하셨습니다. 저처럼 이제 항해학과 졸업하고 배도 졸업하셨는데 해상부 공부해가지고 박사학위 받으셨고 대를 해설대학 교수 오래 하시다가 상해 해설대학으로 옮겼어요. 근데 중국은 이제 교수들이 그 로펌을 할 수 있나 봐요. 그걸 할 수 있나 봐요. 그래서 지금은 이제 윈텔이라는 곳에 지금 시니어 파트너로 활동하고 계세요. 그래서 이제 실무도 하고 해상 강의를 하시니까 굉장히 좀 디테일한 내용을 잘 하시더라고요.
Wait.
顾老师，我们这边PPT已经打开了，然后我们帮你翻吧。we take a page。
我会说的下一张，好吧？
哎，对，您那个老师你说，然后我们这边帮你翻。
好的。
已经打开了啊，我们这边打过去。
好的。Okay, so now please look at my second slide. So I will briefly discuss 4 questions concerning the revision of the hybrid regime on of the law on carriage or international carriage of goods by sea. Now there are 4 questions concerned. The first question is what the hybrid regime is. The second question is why the hybrid regime has been adopted. And the third question is why the hybrid regime needs to be improved. And the last question is how will the hybrid regime be improved? Okay. Now, before we discuss the 4 specific questions, I would like to look into the anticipation of the Chinese Maritime Code. Well, the Chinese Maritime Code was adopted in 1992. That is exactly 30 years ago. In fact, it's a very long time. And finally, the revision of the Maritime Code has been listed in the legislation plan of the National People's Congress, initialed as NPC. And in fact, a lot of research has been done mainly by the professors of the two maritime universities and of course also other maritime law scholars. Well, now the revision of the Maritime Code is in progress. Well, according to the Chinese law on legislation, the revision of the Maritime Code will have 3 stages. The first stage is for the Ministry of Transport under the State Council to prepare a preliminary draft of the revised Maritime Code to the Ministry of Justice, which has already been done. It was done last year. And now the revision work is at the second stage. That is, it is now the work of the Ministry of Justice to study the preliminary draft and to prepare a draft of the revision of the Maritime Code. And then, the State Council will approve the draft and to submit an official draft to the Standing Committee of the National Congress. And finally, the revised Maritime Code will be adopted by the Standing Committee of the Chinese People's Congress. According to my experience in participating the making of the Maritime Code and other Chinese shipping laws, possibly, it will take 2 years for the Ministry of Justice to prepare and to submit an official draft revised Maritime Code to our National People's Congress. So therefore, hopefully, the Maritime Code will be revised in 3 years or so. Now, the first question is what the hybrid regime is. In fact, the regime, the legal regime governing international carriage of goods by sea, which is contained in Chapter 4 of the Maritime Code, is different, or even quite different, from any of the 3 international conventions governing carriage of goods by sea. That is the Hague Rules, the Hague-Visby Rules, and the Hamburg Rules. And in fact, the hybrid regime consists of 3 parts. I mean, the provisions of the hybrid regime consists of 3 parts. The first part is the provisions which are based upon the Hague-Visby Rules. And the second part of the provisions, in fact, is some mature and reasonable provisions we incorporated or we adopted from the Hamburg Rules. The third part of the provisions of China's characteristics, or we say Chinese characteristics, which are different totally from any of the international conventions. Now, please, let's look at the provisions based upon the Hague-Visby Rules. Well, now the provisions were contained in Chapter 4 of our Chinese Maritime Code, governing the obligation of the carrier to exercise due diligence to make the ship seaworthy before and at the beginning of the voyage, and to to properly and carefully care for the goods under the provisions of the exemptions. That is the catalog of exemptions of the liability of carrier for loss of or damage to the goods, and the provisions governing the limitation of liability of the carrier for loss of or damage to the goods and the loss of right to limit are placed upon those contained in the Hague Whisper Rules. In fact, these provisions are copies of now the corresponding provisions contained in the Hague Whisper Rules. Now, as I mentioned just now, some mature and reasonable provisions contained in the Hamburg Rules are incorporated into the Maritime Code. In fact, in this regard, many provisions are incorporated from the Hamburg Rules, including those concerning the definitions of carrier, shipper, actual carrier, consignee, and goods, the obligations and liabilities of the actual carrier and the shipper, the carriage of live animals and dead cargo, the non-contractual claims, that is, claims against the carrier based upon tort instead of breach of contract, and also claims against the servants or agents of the carrier, and also the bill of lading and other transport document. Well, ladies and gentlemen, if you look at now chapter 4 of the Chinese Maritime Code, the whole chapter looks like a copy of the Hamburg Rules. But I should say the critical or the most important provisions governing, as I mentioned just now, carrier's obligation to exercise due diligence to make the ship seaworthy, the exemptions of carrier's liability for loss of or damage to the goods, and also the limitation of the carrier, limitation of the liability of the carrier for loss of or damage to the goods based upon the Hague Whisper Rules. While the third part of the provisions are covered by the hybrid regime of China's characteristics. For example, now the provisions concerning the period of responsibility of the carrier and delay in delivery, amounts of compensation for loss of or damage to the goods, and the ship's obligation to perform cargo formalities, including the customs formalities, the cargo export licenses, and also the formalities of the port authorities, and also relationship between the carrier and the consignee or a holder of a bill of lading, and a notice of loss or damage to the goods to be submitted to the carrier or actual carrier at the time of delivery or after the time of delivery if the loss or damage is not apparent. And also the carrier's disposal of the goods in case now the consignee refuses to take delivery of the goods, or the consignee fails to take delivery of the goods in time. And also the carrier's lien on the goods to secure the freights or demurrage and other expenses to be payable to the carrier. Now, the second question is why the hybrid regime has been adopted. In fact, in essence, this is a question: why ratification of or accession to a single international convention, among the three international conventions, that is the Hague Rules, the Hague Whisper Rules, and the Hamburg Rules, were not suitable for China. But in this regard, there are three reasons. First, the Hague Whisper Rules were widely adopted at the time the Maritime Code was adopted in 1992, especially by some major shipping countries. But the Hague Whisper Rules, the contents of the Hague Whisper Rules were not comprehensive but simple. If we look at the title of the Hague Whisper Rules, everything is clear. Because the title of or the name of the Hague Whisper Rules is the International Convention for the Unification of Certain Rules Relating to Bills of Lading, as amended by the Whisper Rules. Therefore, this convention basically only deals with certain rules of law, and the rules relate to bills of lading only. Instead, the Hamburg Rules, the contents of the Hamburg Rules are comprehensive and complete. If we will look at the title of the Hamburg Rules, it is clear because it is the United Nations on the carriage of goods by sea. But at the time the Maritime Code was adopted, that is in the year of 1992, we anticipated that the Hamburg Rules would be very much difficult to be widely adopted, especially by the major shipping countries, of course, including Korea and Japan, etc. And therefore would be not beneficial to China, because China, even at that time, was both a shipping power and a trading power. Well, I would like to mention that during the time of the drafting of the Chinese Maritime Code, one of the rules which were decided to follow is that, now the Chinese Maritime Code should be based upon the international conventions which are widely adopted and put into practice, especially by now the major maritime and shipping powers, including our major maritime partners, of course, including Korea and Japan. Would you please just repeat now the previous slide? I missed something. Now, please turn to the previous slide. Yeah, good. And the third reason is that some compromises were to be made between the shipping interests and the cargo interests. Well, during the drafting of the Chinese Maritime Code, our Ministry of, at that time, the Ministry of Communications just represented the shipping interests, mainly the COSCO, then the China Ocean Shipping Company, whereas another ministry, that is the Ministry of Foreign Trade and Cooperation, represented the cargo interests. Well, the shipping interests at that time insisted that the Chinese Maritime Code should be based upon the Hague Rules. But while the cargo interests at that time insisted that the Maritime Code should be based upon the Hamburg Rules. So there should be a compromise between now these two conventions. So as a result, some provisions in fact reflected such compromises, and as a result, now some provisions are different from any of the international conventions. So we say these provisions have the Chinese characteristics. Okay, now the third question is why the hybrid regime needs to be improved. There are several reasons. The first reason is that now the judicial maritime practice in the past 30 years has proved that the Maritime Code lacks some practicable rules, and the Maritime Code exists now some ambiguities and uncertainties. Now, these are the examples. Now, that is why the Maritime Code lack rules governing the use of electronic transport documents. Here, I just want to mention, we noticed that Korea is ahead of China on the legislation of electronic transport documents. So in this regard, during the study of the revision of the Chinese Maritime Code, we deeply felt that China should learn from Korea. And also the Maritime Code lacked rules governing the legal position of port operators who perform cargo loading, stowage, handling, and or discharge, and also the rules governing the identification of carrier. In judicial practice, it proves that while a holder of a bill of lading often faces difficulty to identify who would be or who the carrier is or should be, especially in case a bill of lading does not indicate the name of the carrier. It's very much important for a holder of a bill of lading to properly and timely identify the carrier, because the holder of a bill of lading will make a cargo claim against the carrier. And also, the Maritime Code lacks rules governing burden of proof in cargo claims. Everybody knows what burden of proof in cargo claims, that is, in claims for loss of or danger to goods against the carrier or the actual carrier, is very much important. But while the Maritime Code, in fact, does not indicate a lot of things. Well, the Maritime Code only indicates that if the carrier is to avail of the exemptions, any of the exemptions of his liability, then he should provide proof, provide evidence to prove that the cargo loss or damage was resulted from one of the exemptions. So in judicial practice, disputes may arise as to the issue of burden proof, that is, what the claimant should prove, and what the carrier or actual carrier as defendant should prove in defending the claim. And also, the Maritime Code lacks rules governing the rights of control over the goods. Besides, there are, in fact, many ambiguities and uncertainties with respect to, for example, FOB sellers' rights and obligations, and the identification of carrier, etc. In this regard, I would like to mention, unlike the Hague-Visby rules, but the same as the Hamburg rules, in the Chinese Maritime Code, there are two shippers. One is the person who has concluded a contract with the carrier, and the second shipper is the person who delivers the goods to the carrier or actual carrier for carriage. Therefore, the second shipper is normally an FOB seller. And as you know, China has become the largest commodity exporting country. And according to statistics, nearly 70% of the cargo export from China are based upon FOB terms. So therefore, it's a very critical issue how to legally protect, how to properly protect the interests of the FOB sellers in China, especially while most of the FOB sellers are small traders. Next, please. Well, the next reason of improving the hybrid regime is the adoption of the Hamburg Rules by the United Nations in the year of 2008. Well, I spent 3 years in Anzhuchou representing the Chinese government, and Professor Kim Yung always represented the Korean government. So we worked together in the United Nations, and at that time we became very close friends. Well, in fact, several years ago, I mean, soon after the adoption of the Rotterdam Rules in the year of 2008, well, after comprehensive discussions, the Chinese government has decided to take the wait and see approach. And that is to say, China has not decided to ratify the Rotterdam Rules, but we would wait and see. That is, we should, before the Chinese government decides to ratify the Rotterdam Rules, we should see that now the most of the largest shipping and trading companies, especially our main maritime trading partners, including Korea and Japan, would ratify now the Rotterdam Rules. But we can see that up to today, there are only 5 small countries which have ratified the Rotterdam Rules. So it's far from the date when the Rotterdam Rules were put into practice. So it seems to me that it's quite possible that China will not ratify the Rotterdam Rules. And the Rotterdam Rules may be taken as a model law for various countries to improve their respective law on carriage of goods by sea. In fact, after now the adoption of the Rotterdam Rules, several countries have amended their respective national law, domestic law on carriage of goods by sea, including Germany, Korea, and Japan. And in their amended law on carriage of goods by sea, I can see that now each country has incorporated some provisions, of course, different to agree from the Rotterdam Rules. After comprehensive analysis, we have realized that the Rotterdam Rules contain some reasonable and mature provisions which can be or should be adopted or referred to, improving our hybrid regime. The last reason to improve our hybrid regime is the necessity of coordination of our maritime code with the general civil laws. Well, ladies and gentlemen, we're in China. Maritime law is deemed as a special law as compared with now we say the general civil law. And therefore, the maritime law needs to coordinate with the general civil law. That is to say, as special law, the contents of the maritime law, or we say maritime code, are basically limited to those legal rules which are different from the general civil law, which are necessary to properly regulate the relations concerning maritime transport or other issues with respect to ships. However, now the maritime code, in fact, lacks such coordination in many aspects. This is mainly because the maritime code was adopted before the general civil laws, which are now mainly codified by our civil code, which was adopted 2 years ago. Now, I will just give one example. Everybody knows insurance contract or marine insurance contract. Now, the parties to a marine insurance contract under the Chinese Maritime Code are the insurer and the insured, but the parties to an ordinary insurance contract under our insurance law are the insurer and the applicant. Yes, maritime law is a special law, but it should not be so special to make now the parties to an insurance contract or the marine insurance contract and different from the parties to an ordinary insurance contract. So this is a good example of non-coordination of maritime code with our general civil laws. Please, next. Now, the last question would be how our hybrid regime should be or may be improved. It seems clear that as a result of so many research work done today, the following will be the main points on improvement of our hybrid regime. The first is adopting reasonable and mature provisions from the Rotterdam rules. First is the rules contained in the Rotterdam rules governing electronic transport records. Well, ladies and gentlemen, in the shaping of the rules governing electronic transport records in the Rotterdam rules, in fact, there was no sufficient experience in this regard. But the draftsmen, including our Professor Kim and myself, realized at that time that there should be some basic legal rules governing electronic transport records to be contained in this international convention. Otherwise, it will cause harm to the practice in the use of any electronic transport documents. And also now the definition of maritime performing party, because we needed to refer to the definition of maritime transport performing party to improve our definition of actual carrier. And the rule contained in this international convention concerning the identification of carrier. In my understanding, the rule in this regard is very good, it's reasonable. And also the rule governing storage of deck cargo, where decks are specially fitted to carry containers or vehicles, because there are some disputes as to whether a container or vehicle can be stored on the deck of an ordinary ship instead of a container vessel. And the rule governing the rights of control over the goods and the transfer of the right. And the rule governing the burden of proof in cargo claims, which is also reasonable to my understanding. But ladies and gentlemen, we will never, it is clear that we will never adopt the following rules contained in this international convention. First, documentary shipper, because adoption of the rule governing documentary shipper will cause harm to the FOB sellers' interests in China. And also the volume contract, which is very much obvious and which was strongly proposed by the United Nations. And also the delivery of the goods without bill of lading, because it may also cause harm to the cargo exporters from China. And the limits of liability for loss or for damage to goods, which are too high and beyond the commercial need. And also the rules governing jurisdiction and arbitration, which would compel Chinese traders, especially Chinese consignees, to be involved in arbitration in court proceedings or arbitration proceedings occurring abroad. And the second consideration is to removing the existing ambiguities and uncertainties, and also filling in the existing gaps. As I mentioned just now, in the Admiralty practice in the past 30 years, well, it proves that the Maritime Code has a lot of ambiguities and uncertainties, and also some gaps. For example, we should make it clear what will be the FOB seller's position, legal position, and also its rights and obligations in our revised Maritime Code. Well, the FOB seller, as I mentioned just now, is deemed as the second shipper in the Chinese Maritime Code. But while the FOB seller becomes a shipper only because he delivers the goods to the carrier or actual carrier for carriage. Therefore, his rights and obligations should be based upon his act of delivering the goods to the carrier and actual carrier for carriage. Therefore, he shall not have all the rights and obligations which the second shipper who has concluded a contract with the carrier will have. So we should distinguish now the rights and obligations of the two shippers. It is possible that the FOB seller will be separated from the scope, the definition of shipper. For example, we may name the FOB seller as a consignor instead of a shipper. And secondly, while the port operations rights and obligations by means of now deeming a port operator as an actual carrier. Well, ladies and gentlemen, China is the largest country of ports operation, and in our definition of actual carrier, an actual carrier is a person who is entrusted by the carrier to perform the whole or parts of the carriage. However, there are disputes as to whether now cargo handling of loading and discharging is within the scope of carriage. While several authorities of maritime law deny that cargo loading or discharging is within the meaning of carriage, and therefore now port operators, even if entrusted by the carrier or active carrier, have not been taken as an active carrier. So therefore, if there's any cargo loss or damage occurring during the operation in port, in loading or discharging, then the consignee, if now the consignee makes a claim against the carrier, for example, on a container lines in liner shipping, then the carrier is entitled to limit his liability. However, if the consignee makes a claim against the port operator, then the port operator should pay full compensation for the loss of or damage to goods. That's very unreasonable. So such a situation should be changed. But there's one solution, that is to deem the port operator as an active carrier expressly in our revised Maritime Code in the future. And also we needed to improve the calculation of the amount of compensation for loss of or damage to the goods. Currently, according to Article 55 of our Maritime Code, in case of loss of the goods, the amount of compensation will be calculated according to the CRF price of the goods so lost. That is to say, well, the consignee will not be able to claim for loss of profit. This is unreasonable. This is different from the Hague-Visby rules, and also the this is not. This is different from the yes, the Hague-Visby rules and also the Rotterdam rules. So therefore, it's quite possible that we'll change this article to the effect that now the amount of compensation for loss of goods will be based upon the current market price at the time the goods are delivered or should have been delivered, in order to enable now the claimant, that is the consignee or the subrogated cargo underwriter, to claim for loss of proving profit only where there's no current market price will the amount of compensation be determined based upon the CIF price of the goods lost. In case of damaged goods, it will be the difference in current market price. That is the difference of the between the current market price of the sound goods and also that of the damaged goods. Now, if there's no such price, then it will be determined according to the current admiralty practice by the depreciation ratio in the value of the goods so damaged. Next, please. Then the next consideration is to coordinate with the civil code. There are two. There are several aspects in this regard, but a particular issue is the carrier's lien on goods carried. Well, according to Article 47 of the Chinese Maritime Code, the carrier is entitled to exercise lien on the goods for unpaid freight, demurrage, or other expenses to be payable to the carrier only when the owner of the goods are obliged to pay the unpaid freight or other expenses. That is to say, now, if the ownership of the goods at the time of delivery or before delivery at the port of discharge is not owned by the person who has the obligation to pay the unpaid freight or other expenses, then the carrier is not entitled to lien such goods. And in fact, while the ownership of the goods during the maritime transport may be transferred from one person to the other according to the terms and conditions contained in the contract of sale of goods. And the carrier is not a party to such a contract and normally has no knowledge of the transfer of the ownership of the goods. So in practice, especially soon after the adoption of the Maritime Code, there were several reported cases of wrongful exercise of lien by the carrier on the goods. Everybody knows that the clause of lien on goods is for the purpose of protecting the interests of the carrier for the payment of the freight or other expenses. But in fact, now, soon after the adoption of the Maritime Code, many shipping companies just complained to the fact that this clause could not protect them, but only caused harm to their interests. So this should be changed. In fact, now the Chinese contract law adopted in 1999, which has already been abolished, stipulated that the carrier can exercise lien on the goods carried whether or not now the owner of the goods is obliged to pay now the unpaid freight or other expenses. So we will follow now our civil code maintains such a provision, and we are clear that we will just make copy of now this rule from our civil code into the revised maritime code in the future. And the last point is setting up special rules applicable to domestic carriage of goods by sea. Well, ladies and gentlemen, now the chapter 4 of our maritime code is contract of carriage of goods by sea. But in fact, our chapter 4 is only applicable to the contracts of international carriage of goods by sea. That's to say, this chapter is not applicable to the domestic carriage of goods by sea. Well, China has a very large domestic maritime, has a very large market of domestic carriage of goods by sea. And we do not have any special law governing the domestic carriage. So Chinese law needs specific rules, specific and practicable rules governing such carriage. So we have decided to make now the maritime code applicable to the domestic carriage of goods by sea. It's not finally decided yet. There are several alternatives, several options. One is to set up a special chapter, one chapter governing such carriage. Another one is to set up one section governing such carriage within the revised chapter 4 of the Maritime Code. But anyhow, it's quite certain that after revision of the Maritime Code, the code will be applicable to domestic carriage of goods by sea. It's almost decided that we would adopt the so-called minimum dual systems. That is to say, after revision of the Maritime Code, there are two systems. There are two legal systems or two legal regimes. One regime is to govern the international carriage of goods by sea, and the second regime is to govern the domestic carriage of goods by sea. But due to the existence of so many similarities or different nature between the two carriages, so the two systems should be the same as much as possible. Now, according to such a consideration, the provisions or the rules to govern the domestic carriage of goods by sea will have the following three special rules or special points. One is the transport document will be waybill instead of bills of lading. In fact, in the domestic carriage of goods in China, whether by sea, by road, by rail, or by air, now the transport documents are waybills, which in fact learned from the former Soviet Union. And the basis of liability applicable to the domestic carriage of goods by sea with regard to carrier's liability currently is strict liability. That is, in case of loss or damage to the goods or delay in delivery of the goods, the carrier can be exempted from liability only in cases where the loss or damage or delay is caused by force majeure, by any fault or negligence of the consignee, or I'm sorry, of the shipper or consignee, or caused by the packing of the goods, or the inherent nature or vice of the goods so carried. So this is called the strict liability, especially under English and American common law. But we have not decided whether to maintain the strict liability or to replace it by liability based on fault. If now the fault liability is adopted, then the carrier in domestic carriage of goods by sea will be liable for the goods only when he himself or his servants or agents or active carrier committed any fault or negligence. But this is not decided yet. And the third point is the limits of liability. Now, currently, there's no limits of liability available to the carrier in the domestic carriage of goods. That is to say, in the case of loss of or damage to the goods, the carrier should make full compensation for such loss or damage. But there's one view that in the domestic carriage of goods, the carrier should be able to avail of limits of liability, and the limits of liability are suitable to be the same as those now contained in the Chinese Maritime Code, which are the same as those contained in the Hague Whisper Rules as amended by the 1974 SDR protocol. Because according to statistics, while the current limits of liability, that is those contained in the Hague Whisper Rules, are sufficient or adequate to compensate for the actual loss arising from loss of or damage to the goods. Because as you know, now the value of the goods carried by sea, whether international or domestic, are not very expensive, in fact. So it's certain, it has been decided that the revised Maritime Code will setting up special rules applicable to domestic carriage of goods by sea. But although we have already have a lot of discussions, now the basis of liability and the limits of liability have not been finally decided yet. So it's further discussions will be needed. Well, all these are my introduction to the hybrid regime, which is very much peculiar in the international legislation of carriage of goods by sea. Thank you so much. Thank you very much, Professor Kim, for your invitation again.
Thank you. Professor James Hu, thank you so much for giving us such good and very informative, inventive lecture. Thank you so much once again.
Thank you, Professor Kim. I'm looking forward to meet you again. It does not matter whether we can meet in Korea, in Seoul, or Shanghai, everywhere, even in Africa.
Yes, I have one question.
Yeah.
You mentioned that you and I became friends when we worked together at the Rotterdam rules. Rotterdam rules making, and you and I tried to keep the nautical port exemption.
Yeah.
The Rotterdam rule, but you didn't mention about the nautical port defense. You wanted several provisions from Rotterdam rule should be inserted in the future Chinese maritime code, but you didn't mention about the fate of nautical port exemption. I understand that China and Korea still maintain a nautical port exemption. What is your opinion on the abolishment of nautical port exemption in the Rotterdam rule?
Okay, well, thank you very much for your very critical question. Well, we have decided to maintain the nautical port exemption because the Chinese law, the Chinese maritime law, should be in line with the widely adopted legal rules in the international community, especially the rules adopted by the major other major shipping powers, including Korea and Japan. So before now, the major shipping powers, especially our major maritime trading powers, change their law to abolish the nautical port exemption. China will always maintain the nautical port exemptions.
Thank you so much. China and Korea and Japan should go together with the nautical port exemption. Thank you so much. 잠깐만요. 제가 잠깐 설명드리면 하이브리드라고 이렇게 이야기해가지고 제가 이제 please give me 2 minutes to give some explanation on the hybrid version. 저는 그래서 이제 combined 복합 운송인 줄 알았는데 그게 아니고 중국 해상도에 우리 조약이 이제 2개가 있지 않습니까? 그래서 헤이그리스니 조약을 기본을 하면서도 함부르크 룰도 들어가 있고 중국의 필요한 것도 들어가 있어 3가지가 있다. 그런 식으로 이제 하이브리드라고 이제 이야기를 하고 우리가 이론적으로는 하나의 조약을 택하고 3가지가 있다. 그걸 이제 로테르담 룰이 최근에 나왔기 때문에 이제 어떻게 집어넣는가 하는 이야기를 그렇게 하신 것 같아요. 제가 질문한 건 우리가 항해과실 면책이라고 있거든요. 그래서 운송비 화주에 대해서 항해과실 면책은 이제 책임을 지지 않는 제도가 있는데 로테르담 그래서 우리가 폐기를 해버렸어요. 그때 쟁수하고 저하고 일본하고 반대를 했어요. 한국에는 일본은 중국에 있으니까 그걸 유지하자 했는데 미국 사람들은 없애버렸습니다. 그래서 어떻게 할 거냐 그랬더니 이제 중국도 계속 가지고 있겠다 이런 이야기를 했거든요. 네, 들리나요? 예, 들리죠.
Okay, Professor Hu, I'm really appreciate your good lecture. I fully understand your intention of the Chinese government and also really. And I have some question about your hybrid regime in China. As far as I know, normally the hate speech rule will reflect on the interest of the shippers or customers, whereas the Hamburg rule, okay, and hate speech rule has a tendency to apply the benefit or interest of the shipper, like a Costco or China Street or CU. And having said that, as you already mentioned, the type of hate speech rule is widely adopted rather than Hamburg rule in shipping lines. But can we understand that the China, the hybrid regime, that means that the Chinese government attaches more importance of the shipper or trade side rather than carriers' interest? Maybe there's a various reason because after the COVID-19 period, the carriers have lots of money, and also the customer was not getting benefit. Maybe there's some complaint from the customer side, the shipper side. Maybe that's the reason why the Chinese government decided to change the policy or to apply that hybrid regime. I just want the reason exactly why you need to change your policy. That's my question.
Possibly, this is a matter of my computer. Professor Kim, well, could you please just summarize what the question again? Not very clear to me.
People normally a lot of carriers they use Hague fuel, yeah, as the Chinese, for example, your country, China shipping before and Costco and the CU line as well. But all of a sudden, Chinese government decide to adapt Hamburg rule partially. Maybe the meaning for that the changing is to protect more shipper side rather than the carrier side. Am I right? Maybe that's your intention of the Chinese government.
Okay. I hope I have already caught your main idea. Well, I mentioned that the hybrid regime is, I mean, the most important issues of the hybrid regime. That is what the carrier's obligation to exercise due diligence to make the ship seaworthy, to properly and carefully care for the goods, the exemption of liability for loss of or damage to the goods, and the limits of liability of the carrier. These are very much important issues, and these very much important issues are based upon the Hague-Visby rules. Because maybe I failed to express very clearly or correctly. Because at the time when the Maritime Code was adopted, the Hague-Visby rules. In fact, the Hague-Visby rules were not very much widely adopted in the international community, but the Hague-Visby rules were adopted by many major and important shipping powers, the shipping countries. Well, at that, as I mentioned just now, even at the time of the adoption of the code in the year of 1992, China have already become a shipping power and also a trading. Now the situation has not been changed. Now, according to the statistics of UNCTAD, China, in terms of the tonnage of the merchant freight, China ranked second. Of course, the first one is always Greece, and also according to UNCTAD, China first in terms of the volume of international trading. So therefore, it's very much clear that the Chinese government and also People's Congress should well balance the interests of the ship owners and also the interests of the cargo traders. So, in fact, if I'm not mistaken, we incorporated a lot of provisions from the Hamburg rules, mainly to supplement the rules contained in the Hague-Visby rules, because the Hague-Visby rules are too simple. Of course, now, yes, I have to admit that due to the fact that there are so many FOB business, and there are so many small and medium-sized cargo traders in China who export the commodities on FOB prices. So it is a concern on legislation to properly, to duly protect the interests of the small cargo traders. But this can be done only at the premises that the overall interests of the shippers, overall interests of the ship owners and the cargo owners are well balanced. And so I believe that the Chinese government will maintain such a basic policy. Of course, otherwise, the Chinese maritime law will not be in line with the international rules, which are widely adopted in international community. And well, as this is why, as I mentioned just now, we have decided not to adopt the rules governing the documentary shipper contained in the Rotterdam rules, because according to the rule on documentary shipper contained in the Rotterdam rules, well, only when the FOB seller is listed as the shipper in bill of lading or in the electronic transport record, will the FOB seller has the rights and of course at the same time obligations same as a shipper. But to list the FOB seller as the shipper in a document in a bill of lading or electronic transport record, it is subject to the agreement of the shipper. That is, if now the FOB buyer as the shipper does not agree to list the FOB seller as a shipper in the bill of lading or electronic transport record, then the interests of the FOB seller cannot be or may not be properly protected. So this is why we have decided not to adopt the rule governing documentary shipper contained in the Rotterdam rules. So we may adopt some provisions, rules and provisions from the Rotterdam rules when the Chinese Maritime Code is revised. And I suppose we would adopt more rules and provisions from this convention than Korea, Japan, and Germany has already done. But the basic policy will not be changed. Thank you very much.
Thank you so much. I understand that China will maintain to protect the ship owners' interest more than the shipper, but in recent days, the FOB sellers wanted to be protected more than the current situation in China. So you want to give some weight to the cargo owner, but however, China will maintain the shipper's interest more than the ship owner's interest more than the shipper. Is it right?
Well, we will maintain our policy to balance the interests of the ship owners and the cargo owners, because China is a big shipping country and also a big trading country.
Thank you.
But anyhow, yeah, Professor Kim, there's one rule. There's one primary rule. That is, we should follow the common attitude, the common way which adopted, which are applicable in the big shipping companies, such, of course, including Korea and Japan, etc.
Okay, thank you. Thank you so much. From the perspective of Hague-Visby rules, Hague-Visby rules try to protect ship owners' interest more than the shippers' interest. So I believe that China and Korea and Japan is the country to protect ship owners' interest more than the shipper. Thank you. Thank you so much. 우리 박수 한번 보내주세요. Thank you.
Thank you very much.
See you next time in China, Tokyo or Korea. Thank you. Thank you.
No problem. Even if in Africa.
Africa. Thank you. Thank you so much.
Thank you. Bye bye. Bye bye.